Hi, I'm Patricia Trainor, Managing Editor for HR.blr.com. In our first video, I discussed recent pro-union activity in the National Labor Relations Board, or the NLRB, the federal agency charged with enforcing and administering the National Labor Relations Act, or the NLRA. For details on what the NLRB activities have caught the attention of employers, click on the link that you see on your screen. Today, I'm going to provide some legal do's and don'ts for employers, along with some specific steps they can take to keep employees happy and to maintain a non-unionized workforce. Employers are often confused about what they can legally say to employees about unions, and they therefore often train their supervisors and managers to say nothing. Many experts in union organizing believe that this is a mistake. Under the NLRA and related case law, there are only a few things that employers cannot do in terms of communicating about unions with their employees, and these can be summed up in the acronym TIPS. First, employers can't threaten employees with adverse action if they support a union. For example, they can't threaten to close the facility if the union is voted in. Second, employers can't interrogate employees about their union activities. This means that employers cannot be asking employees questions about their union activity, such as, did you get a union authorization card, or why are you so interested in that union? Also, employers cannot promise benefits to employees if they vote against the union. And employers may not spy on or conduct surveillance of employees' union activities. Beyond those limitations, it's absolutely legal for employers to discuss unions with employees regarding facts, experiences, and their opinions about unions. For example, employers can say that a union will not guarantee better wages. Employers can explain that because a union is the exclusive representative of employees, issues such as a simple schedule shift, for example, would need to be presented by and negotiated with the union, so there would be no one-on-one with management anymore. Employers can also explain that unions are costly. They cost money in the form of dues that employees need to pay. Employers can also let employees know what their experiences with unions have been. For example, they can tell employees when a local company was unionized, wages went down, not up. Now, to maintain a non-unionized workforce, I've put together 8 tips for employees. First, start at the very beginning. From the beginning of the employment relationship, let your employees know your opinion on unions and why a union would not be right for your organization. You can include a union position statement with orientation materials and also in the employee handbook. Second, be pro-worker, not anti-union. If employees feel they have a voice at work, they're unlikely to look to a union to provide them with one. Supervisors and managers should have an open-door policy so that employees feel they can raise issues and concerns without fear of retaliation. Third, remember the golden rule. We all want to feel that our work is valued. Make sure that your company has competitive pay practices in place and also that you recognize employees when they do a good job. 4, run a safe, secure, and fair workplace. Try surveying your employees to learn how they feel about these issues and then respond to employee concerns. 5th, communicate. Have an interactive communication system in place. Give your employees a voice in decisions that will affect them. 6, which is related to communicating, explain unpopular decisions. You need to discuss with employees decisions that are unpopular. Explain why they're important to the company. 7, be responsible. Take responsibility for your decisions, both the good and the bad. Finally, have an effective grievance procedure in place. Make sure your employees know how to file a complaint and raise issues of concern. If employees feel that their concerns are heard, they're less likely to turn to a union to be their voice with management. Now, it's important to point out that these steps should be taken before a union campaign begins. Because if an employer suddenly changes its policies or its practices when a union campaign begins, it may be accused of an unfair labor practice. I want to thank you for joining us today. For more information on the most recent NLRB activity and how to stay union-free, visit hr.blr.com.